Hi, this is Kyle Ingram. I'm an attorney in Washington, D.C., and I help out federal employees with EEO and MSPB matters. Today I'm going to be talking about final agency's decisions. Should you request one or should you go for an EEOC hearing? Now, to me, this is a very simple answer, and I'm just going to give it to you up front. I almost always tell people go ahead and request a hearing. You can always make the decision later to come back and change your mind. But if you wait until a final agency decision, you can't change that later. You're stuck with that decision. So I'm going to go through some details here about what a final agency decision is, what this decision really means in terms of your case. And then I'm just going to tell you a bit about why you should be thinking strategically in this case. Before I get started, this is not legal advice specifically for you. You should talk to an attorney if you have any specific questions about the application of any of these general principles to your situation. This is just legal information only. Okay, so let's get you situated in the realm of the EEO complaint process. When do you have to make this decision? Well, initially, you're going to have the informal process. And then after that, you're going to have the formal complaint process where the investigator gathers information about your case. And at the end of it, the investigator provides the agency with a report of investigation. And at that point, once they've given it to you, you've got 30 days to request a hearing. And by default, if you don't request a hearing, you're going to be getting a final agency decision. So that kind of gives you the roadmap as to where you are in this process. Now, a final agency decision, if you don't request a hearing, that final agency decision can be appealed to the EEOC. So you're not at a dead end. You don't have to accept the agency's word as final, but you're not going to have the opportunity to go and get discovery. Discovery might be really important. So that's where, in the next slide I'm going to show you, you're going to need to make that decision. That's what's going to break one way or the other in any particular case, in my experience. Now, you can't elect a hearing after 30 days, meaning if you wait too long, you're going to get stuck with that final agency decision. The good news is if you request a hearing, you can always withdraw that hearing. Or withdraw that hearing request. That will put you back into the final agency decision line. So there's no harm, no foul there. The worst that's going to happen is you've spent a couple of months waiting that you otherwise wouldn't have had to get this final agency decision. But let me be clear, the vast majority of final agency decisions go against complainants. That's just the reality here. So if you're choosing a final agency decision, you should have a good reason for doing so. But if you are in doubt, I always advise people to choose the EEOC hearing process. Again, you can change your mind later. A judge will be more than happy to help you to withdraw your hearing request and put you in line for that final agency decision. Now, there are some good reasons to get a final agency decision. FADs are, as I said before, they're usually not favorable. I have gotten FADs in my client's favor before, but it is definitely not the norm. And there's two situations in which I would generally consider going for a FAD. The first one is where the juice is not worth the squeeze, right? So if you've got, let's just say, a hostile work environment case that you're really not interested in pursuing, you're no longer around that manager, maybe you've moved on to a different agency, it just isn't worthwhile. You can keep your options open by requesting a final agency decision and not going through the process of discovery that would be required if there's an administrative judge involved. So that's one reason to do it. And frankly, that's the majority of people that I've advised to seek out a final agency decision, is just either it's not worth their time, they don't have the evidence, or a combination of the two. Now, there are some situations where you might still want to request a final agency decision. That's because you want to foreclose the possibility that the agency is going to get discovery against you. Maybe that's because it's a waste of time, because sometimes it verges on harassment, and maybe sometimes you just want to hurry up the process because you know that at the end of the day, the agency is going to be able to issue its own final agency decision that may disagree with the judge anyways. So in that case, might be better just to get a final agency decision as quickly as possible, conserve your resources, and move forward. So these situations are typically rare in my experience. And for the vast majority of individuals, I'm going to tell you, you should definitely consider getting an administrative judge involved in your case. And that's because what the administrative judge process does is it allows you to get discovery on evidence that isn't already in the report of investigation. This is particularly important for intentional discrimination, disparate treatment type cases, because in virtually all of those cases, you're going to need to be able to prove that the agency manager or whoever's making this decision, that person was intending to harm you because of your race, religion, national origin, whatever the specific category is. And that's usually going to involve pretext. You're going to have to prove that they're lying in some way. That is complicated, and I would really never consider going for a final agency decision unless and until I had spoken to an attorney and I was clear-eyed about what the choice was that I was making and why I was making it. But everybody gets to make their own decision, and you should talk to an attorney about your situation before you make a decision to go for a final agency decision or make any decision about your case. So that's just my view. I think this is going to be really helpful for a lot of people because I do get this question a lot. So hopefully this has helped you out. So thanks for watching today. If you'd like to book a free consultation with me, I do free consultations throughout the week. You can go to my website. There's a button there where you can sign up for a free consultation, or you can call my office at this number, 202-459-4563, and you can sign up for a free consultation there. That's the best way to get in contact with me if you have specific questions about your federal EEO matter. Thank you.